panel, and that is much easier to do if everyone is closer to the front. Thanks. So we'll go ahead and get started now. My name is Jill Goldenzeal, and I'm a professor of international law and international relations at Marine Corps University in Quantico. And before I start, I am required to tell you that I do not represent the U.S. government, and that is probably clear when I'm talking about refugees and migration. We have a great panel today with a variety of perspectives on the law and politics of displacement. Global migration and forced displacement are currently at an all-time high. And forced displacement simultaneously presents one of the greatest human rights challenges of our time, a challenge for both states who seek to manage their borders and preserve their sovereignty, and a human rights challenge, and a challenge for existing laws involving population displacement. Many of the international laws and states' domestic laws involving management and treatment of refugees and migrants were designed in a very different time than the world we currently live in. The 1951 Refugee Convention, for example, includes no provisions for how states should handle mass influxes of what are now called mixed flows of refugees and migrants, and no provisions for responsibility sharing, which many states like to call burden sharing, for people displaced by war and violence. The international community and states within it are struggling to apply existing legal frameworks to a rapidly changing humanitarian and political situation. We have a wonderful panel representing a wide range of perspectives in the field, including academia, the UN, international NGOs, and government. As I mentioned, I would like to make this panel as interactive as possible. So after I introduce the panelists, they'll speak for about 10 minutes each, and then I'll start us off with a question or two to get the conversation going, after which point we will open it to the floor. And we'll also give the panelists a chance to ask questions of each other to promote a lively discussion. So first, I'd like to introduce our panelists. To the left of me is Itamar Mann, and he is going to speak about the history of organized mass population movement in international law. Itamar is an associate professor of law at the University of Haifa in Israel. His research focuses on refugee and migration law and human rights issues more broadly. He often engages history and political theory beautifully, I might add, in his work. His book, wonderful book, Humanity at Sea, Maritime Migration and the Foundations of International Law, was published by Cambridge University Press. Alongside his academic work, he is active as a lawyer for the UK-based human rights group, the Global Legal Action Network, and writes fantastic pieces in the popular media. Next, we have Dan Sullivan. Dan will speak on political and legal challenges surrounding the Rohingya refugee crisis. Dan is a senior advocate for human rights at Refugees International. His work focuses on Myanmar, Sudan, South Sudan, and other areas affected by mass displacement. He has nearly 2 decades of human rights and foreign policy experience, having worked for Save Darfur, the Brookings Institution, Human Rights First, and the Albright Stonebridge Group, where he assisted former Secretary of State Madeleine Albright in her role as co-chair at the Genocide Prevention Task Force. Alice Farmer will speak about legal protection challenges involving forced migration from Central America. She is the legal officer for UNHCR's regional office in Washington, D.C. She leads the legal team there on strategic litigation, due process, and access to asylum in the United States. Alice has 15 years of experience in refugee rights, having worked in other offices of UNHCR and also for NGOs, including Human Rights Watch, the ACLU, and the Norwegian Refugee Council's Internal Displacement Monitoring Center. She has a significant research and advocacy background with a focus on children's rights and has founded Human Rights Watch's global campaign to end immigration detention of children, which has done really phenomenal work and published fantastic publications as well. She is also widely published in academic journals. Professor Christina Campbell will speak on family detention and family separation at the US-Mexico border. She is professor of law and co-director of the Immigration and Human Rights Clinic at the University of District Columbia David A. Clark School of Law. Her impressive litigation, teaching, and research interests are concerned with the rights and regulations of non-citizens in the US at both the federal and subfederal levels. Her research agenda seeks to contribute to the scholarly literature at the intersection of immigration, civil rights, and race in the law, and she critiques and analyzes in this research the various laws impacting non-citizens, and the potentially discriminatory motivations behind these laws. With these biographies, you can see how we have a panel that represents a vast range of experience with refugee and displacement crises and migration crises throughout the world, and I'm really looking forward to hearing their perspectives. With that, I'll turn it over to you, Tamar.
Thanks, Jill, for this really very generous introduction, and I'm excited to be on this panel with these co-panelists, and very much looking forward to hear what everyone has to say. It's really quite strange and even somewhat ridiculous to be speaking in such an enormous room. A number of years ago, we had been discussing how migration really needs to become one of the main issues of international law, and it seems like we have been allocated the largest room in the conference, which is appropriate for our ambition, but I'm not so sure that it would be my preference in this context. In any case, I'm hoping that, as Jill said, we can have a really a conversation in the Q&A session. What I would like to do today is share with you a piece of ongoing scholarship, a piece of work that I've been developing together with another scholar named Umut Usu. And our panel is called The Law and Politics of Displacement. And I think what I would like to do is present this as a kind of background, historical background and general background about displacement in international law, really from a legal and political perspective. And I'm going to be focusing specifically on compulsory movement of populations in international law. I think at least those of us who come with a human rights background, and perhaps all of us, would normally think that international law generally prohibits compulsory movement of populations, of people more generally. This is because I think international human rights law has created as a central figure the individual and the dignity of the individual. We think of deportation is a compulsory legal process oftentimes, and it's indeed internationally completely internationally acceptable to deport someone in a compulsory way, provided that they have access to fair procedure and the duty of non-refoulement is met. But apart from that, when it comes to groups, we don't think of the movement of groups in a compulsory way as something that contemporary international law engages with and allows. And the argument that I want to set forth in the minutes that I have allocated for me is that indeed international law in its history has been engaged in this project as a form of governance, transnational governance of populations. This is really quite emphasized when we go back to the international law of the League of Nations period. Then it becomes during the during the human rights revolution less visible, but is now experiencing a kind of resurgence. So I think that we need to think about this and kind of confront it head on, and that's part of the argument that I will be making. The foundational moment, perhaps, in this history of the compulsory movement of populations is the 1923 Lausanne Agreement that facilitated the Greek-Turkish population exchange. This agreement came against the background of a number of other initiatives to displace populations in a compulsory way. Some of them were facilitated by law, such as the Greek-Bulgarian population exchange. Others were simply done in as a brute use of force, such as in the context of the Armenian genocide. However, during the 1920s, this project, which did not only have to do with a redistribution of populations, i.e. A Greek Christian minority from Asia Minor going back or being removed to Greece, not going back, but being removed to Greece, and a Muslim minority from Greece being removed into Turkey as it was established as the Republic of Turkey. But it was also about a redistribution of property. A mixed commission was established at the time to indemnify and kind of restitute property that was left on each side of this exchange, only with partial success. And but it was a kind of legal technology that the people that were involved in were not only Greeks and Turks, of course, but also the internationalist elite of the League of Nations. It came to be very recognized under the name of Fridtjof Nansen, who indeed won the Nobel Prize for this initiative. And this initiative is a kind of, as I said, there are a number of other similar initiatives at the time, but it does kind of operate as a little kind of bang that had ramifications all over the region and in other colonial areas of the world in particular, as a kind of way to establish states in a post-colonial period that will have a self-determination through an idea of a homogeneous population. So the mixture, or the idea of mixed populations, is understood as a kind of a bad thing for the right to self-determination. It won't allow stability and stable states. And this is thought of as a kind of operation, just like a doctor that injures a patient to allow them to live many more years. So the sources of the time talk about population exchange. And one of the places where I have studied a little bit in this project that this has ramifications is in Israel-Palestine. I can talk about that more in the question and answer period. After the Second World War, we have a number of treaties. During and after the Second World War, we have a number of treaties that have to do with the movement of German populations, including after the war, of course. But then quickly, we move into the human rights era. And here, I think that a number of legal instruments, as well as a kind of legal consciousness, suggest that the newfound dignity of the individual does not allow this. Indeed, as the decades progress, moving into the 1990s, this becomes a paradigm of a kind of criminal act of ethnic cleansing. So the same policy that held a pride of place in the League of Nations period now is suspect as one of the worst things that one can do as a general matter. We see this in the Universal Declaration of Human Rights that protects a freedom of movement, more importantly in the Genocide Convention from 1947, during armed conflict in Article 49 of the Fourth Geneva Convention that prohibits the movement of the forced movement of populations, and in the human rights treaties as well in 1966. This is all one story of a progression where the compulsory movement of populations becomes something that we just simply do not do. How many, am I 8? Okay. But my argument here is that we're living through a change in that. And now, and I think that the roots of the change can be located in the 1990s with the kind of recognition of rights for groups under temporary protection status arrangements. But in this period, especially in the context of readmission agreements that the European Union has been concluding with partner states and African states, for example, and most specifically in the context of the EU-Turkey deal, which is a kind of, ironically, an arrangement concerning the same area of the world, we have an initiative to deport people by virtue of their status identity as a group. In the EU-Turkey deal, this concerns Syrians in particular that are moved back to Syria based on their identity as a kind of collective determination rather than through an individualized process. And I will say here that we have in my school in Israel an initiative to do clinical work on the Greek island of Chios, where students are involved in determinations regarding the status of asylum seekers that cross the Aegean and come into Chios. And we see this in a very, I think, painful way. How these collective identities are becoming, in these processes, the determining factor in terms of compulsory movement of individuals in large numbers back to where they have been traveling from. And that was the present moment. And in the 1 minute that I have left, perhaps, I just want to say a few things about the third aspect of this project, which is takes a look to the future and tries to think about climate change and right now mostly voluntary and very inchoate arrangements to move large numbers of people in the context of forced displacement and climate change. Now, these initiatives, which I will speak more in the question and answer period perhaps, are not based on a direct violation of individual rights, of course, but they also involve a kind of forced displacement. And as the urgency increases, the need to move large numbers of people at the same time under particular arrangements and instruments increases. So I will stop here, and thanks for this time that you allocated to me, and I'm looking forward to hear the others.
Does this sound okay? So I think that sets a great kind of background to the topic we're talking about right now in looking at the law and politics of displacement and the challenges here today that we're facing today. I want to zero in a little bit more on one specific case, one that a particularly acute one that's happening with the Rohingya minority from Myanmar that has been largely pushed out into Bangladesh. I think just to start, I think we're looking at this broader landscape of a challenge of displacement where we've seen the highest numbers since World War II and of displaced, and that's both refugees and internally displaced persons. And we can talk perhaps a little bit in the question and answer some of the broader efforts that have been done with the global compacts on migration and global compact on refugees. Where I work at Refugees International, we cover the general kind of thing, but I've focused very much on the Rohingya. So I say it's particularly acute because we're talking about atrocity crimes and ethnic cleansing that's happening, and 700,000 plus people who were forced to flee as of August 2017 and since from Myanmar, Western Myanmar, into Bangladesh, and adding to people Rohingya who had already fled, you have 1 million Rohingya who are now living in these camps in Bangladesh. And I was just in the camps last month, and I'll be heading back, and have been interviewing Rohingya refugees who continue to come into Bangladesh from Myanmar, and just showing where the lack of progress or any kind of creation of a conducive environment for any kind of repatriation to happen in the near term. But I think to give in a short time, the quick background is that the Rohingya is a minority, an ethnic minority in Western Myanmar that has lived there for generations, but the government of Myanmar has persecuted them for decades, and through a 1982 citizenship law has left them off as one of the ethnic groups to be recognized for citizenship. The government of Myanmar considers them as illegal Bengalis, despite their being able to prove they've been there for generations. So that's really the core of the challenge, is that because they don't have citizenship, they're stateless, and that status creates all kinds of problems for any kind of longer term solution. So where we are today, as I mentioned, there's over 700,000 Rohingya who have fled recently, so adding up to about 1 million. over 1 million Rohingya who are living in Bangladesh now in camps. You still have a few 100,000. The numbers are tough to really nail down because there has been so much movement and restricted access to Rakhine State in Western Myanmar, where these atrocities happened and where these people continue to live and face restricted humanitarian access and restricted rights. So the challenge, the political and legal challenges, you have overwhelming evidence of what happened. A lot of different reports and studies have been done. The UN set up a independent fact-finding mission, which determined that that the senior generals, including Senior General Min Aung Hlaing, the head of the military in Myanmar, should be prosecuted for genocide. You have a State Department report that went out and surveyed 1,000 Rohingya refugees in Bangladesh about what they experienced and came to very similar conclusions. State Department has not come out designating it as any kind of legal determination, whether it's crimes against humanity or genocide, but has said that their findings were very much in line with what was found in the fact-finding mission. And that being, Myanmar security forces surrounding villages, setting them on fire, shooting at people as they fled, mass rapes, just awful crimes that were committed. And so there's this overwhelming amount of evidence. The law group, PILPG, who I think is here as well, who carried out this survey for the State Department, came out with their own assessment saying that there was strong evidence of genocide. U.S. Holocaust Memorial Museum has said the same thing. But despite this evidence, the government of Myanmar continues to deny that this has happened, and that the security forces should be held accountable. So you have the challenge of internally, domestically, within Myanmar. Then the other options that have been explored are going to the International Criminal Court. That's been blocked as if you're familiar with the Security Council dynamics, where often Russia and China come out and because of geopolitics are sort of siding with Myanmar and blocking any referral to the International Criminal Court. Myanmar is not a signatory, but the International Criminal Court has looked at and has started an investigation based on the fact that the crime of deportation started in Myanmar and ended or continued into Bangladesh, which is a signatory. So there are some efforts going on there. I mentioned the fact-finding mission that was set up. That's continuing to carry out its work, at least for a few more months. And there's now an independent mechanism for collecting evidence that was set up by the Human Rights Council, and we'll have to keep an eye on how that transition goes forward. But the idea is to at least collect this evidence so that in the future, whether through the ICC or some kind of ad hoc tribunal, there can be accountability. In terms of the other kind of challenges, and a lot of our work is focused on the U.S. government. There have been some efforts done. There have been a handful of individuals and a couple of military units that have been placed under targeted sanctions by the U.S. government. Vice President Pence, face-to-face with Myanmar's de facto leader Aung San Suu Kyi, criticized what had happened. So there's been some movement, but not nearly enough. And it's groups like ours and others who are pushing for accountability and for addressing those root causes of what happened, to allow for all those Rohingya who are in Bangladesh to return, are pushing for more accountability, whether it's through the mechanisms I mentioned or through more targeted sanctions and pressure on bilateral, other countries who continue to work with the Myanmar security forces. So those are some of the ways that we're approaching it. In terms of a real way forward, it really comes down to it's the government of Myanmar has said that it is it has an agreement with the government of Bangladesh and with the UN, with UNHCR and with UNDP to allow access and start repatriation, but that has gone nowhere. Basically because of Myanmar's the security forces, the government have not only failed to improve conditions, they've actually gotten worse in Rakhine. That became very apparent when talking to people who were recently arriving in Bangladesh still today. So, so it just reiterates the need for pressure on the government of Myanmar to fundamentally change and address those issues. At the same time, there's what we have today is these million Rohingya refugees in Bangladesh, and there's challenges there as well. Keeping in mind where the root causes are and where the main focus should be, there's also issues in Bangladesh, which should deserve great credit for taking in that number of people fleeing, but they refuse to recognize the Rohingya as refugees. And that carries with it a lot of implications for their access to justice, access to education, access to livelihoods, and some fundamental protection issues. The government of Bangladesh has also suggested moving 100,000 of the Rohingya refugees to an island, which didn't even exist a couple of decades ago. It's a buildup of silt in the Bay of Bengal, and they've done a lot of building of more permanent structures and embankments, but have not answered some fundamental questions about protection, about how services would be given, and how to guarantee these that any kind of movement would be informed and voluntary. And I can say from the interviews I had with Rohingya refugees, they're terrified of the idea and know very little about this island other than that it's very prone to flooding and in the historical path of cyclones. So there's a lot of worries also on the Bangladesh side. So I'm happy to talk more about kind of where what those challenges are and what other ways forward. But I think fundamentally it's a need for pressure on the government of Myanmar to address the root causes, particularly that stateless one, to provide citizenship for the Rohingya. And then in the meantime, keeping up the humanitarian aid that's going to the Rohingya in Bangladesh and working with the government of Bangladesh to provide status and protection for those Rohingya refugees. Thanks.
Thanks, Dan, and thanks to Itamar and Jill as well. Jill referred to the idea that when we're talking about refugee law, we are very much talking about a set of laws that were written at a very different time. And I think some of the examples Dan has pulled out illustrate some of the flaws in that regime and how it's not perhaps working now. And so that's a bit what I'm going to expand on now. I'm going to talk about the crisis of displacement in Northern Central America, and with a few illustrations that are perhaps a little bit closer to home, look at how that legal regime is being stretched and tested right here in the United States at the moment. So I think, as my colleagues have mentioned, we've got an all-time high in global displacement, and one of the things that UNHCR does every year is issue a report where we've attempted to count the number of displaced people. And every year right now we keep saying it's more than at any point since the end of World War II, and it's more than last year. And that is a trajectory that has been going on for at least 6 or 7 years. And just every year those numbers come out and feel overwhelming. With 68.5 million people, we're now talking about a displacement population around the world that's the size of the population of Great Britain or France. It's really we're in a situation where a lot of the traditional solutions that UNHCR has worked with for decades are not viable solutions anymore. We used to see about 1 million people a year going home towards the end of the Cold War and in the years immediately following. And right now, UNHCR is running at maybe 250,000 to 400,000 returns every year. So these numbers are high and they're staying high. Itamar briefly referred to climate change, and I think that's a good reminder as well, that the numbers we're seeing now will be dwarfed in a few decades when we're facing, maybe less than a few decades, when we're facing serious displacement from climate change. So there is a real urgency to try and address this legal regime that's being tested and stretched. Let me focus in on Northern Central America. So that's Guatemala, Honduras, and El Salvador. Forced displacement from those countries is on the rise and has been since at least 2014. The numbers are very significant in terms of, not just in terms of US arrivals, but also arrivals in other countries around the region, which is often a very good signal to UNHCR that we are looking at a migration that is a forced displacement migration and not merely an economic migration to the United States. From the beginning of 2014 to around the middle of 2018, the number of refugees and asylum seekers from those three countries went from about 44,000 to over 350,000. Those numbers are continuing to grow. In our most recent set of statistics from mid-2017 to mid-2018, we recorded a 30% increase in the number of asylum seekers fleeing the Northern Central America. Internal displacement, particularly in Honduras and El Salvador, is continually increasing. And so it's definitely something we remain very concerned about. I quickly go over some of the causes of displacement there. We're talking about violent criminal gangs with significant territorial control, much more so than gangs in other parts of the world. On many measures of violence, Northern Central America is one of the most dangerous regions in the world. In around 2016, the El Salvador homicide rates were some of the highest in the world and were as high as they were in El Salvador towards the end of the civil wars in the 1990s. Now you'll hear some conversations about the homicide rates having gone down, but many of the other indicators of violence are still up. Violent deaths, which include police-related killings. Honduras is second only to Syria for the number of violent deaths per population, and El Salvador is fourth on that marker. And other indicators such as gender-based killings, sexual violence, extortions, corruption, all of this continues to be very high. And when we look at impunity for any of these crimes, we see impunity rates of about 90%. So there's very little prosecution. So underneath that, we unsurprisingly see a lot of people fleeing. And UNHCR takes the position that many of those fleeing would very clearly meet the refugee definition. In the US, we have seen particular spikes in unaccompanied children crossing the border and in families coming to the US border, even with the deterrent measures like family separation, like increased detention, very strong rhetoric from this government. We still see very large numbers of vulnerable populations coming to the southern border, including in recent months, an over 150% increase in the number of family arrivals. So I think that's a reinforcement of the message that if you are truly in a forced displacement situation, deterrence is not an effective message to be sending out. But it's not just the US, and I think that's a really important message to send. We've seen massive increases in the numbers of Central Americans claiming asylum in Mexico, as well as increases in Costa Rica, Nicaragua, Belize, and other countries of the region. Since the Central American crisis started, we've also added increased flight from Nicaraguans. So about 40,000 Nicaraguans have requested asylum abroad now. And of course, Venezuela has about 3.4 million Venezuelans outside of the country, most of whom are still in South America or the Caribbean, but we expect them to begin to arrive at the southern border. So what we have then is sort of a perfect storm to test some of the weaknesses in international law. Jill referred a little to concepts of burden sharing or responsibility sharing being something that's very much tested at this point. And I think we see that here in terms of questions around access to territory, in terms of a series of conversations around whether there can be a safe third country agreement with Mexico, to say that transit through Mexico is not a legitimate move. That is very much not UNHCR's position. Other measures to compromise access to territory at the southern border, like restricting availability of asylum for people who cross irregularly between ports of entry. These all speak to whether or not a government is willing to take on some of the shared responsibilities that exist in the refugee regime as it's set out. And then another major test that we've seen in the US at this point is this fascinating discussion around particular social group. I just revealed that I'm a nerd because I called particular social group fascinating. But I do, so.
I think in this room you have a lot of company.
Okay, all right, good. So because much of the displacement in Central America is caused by non-state actors, and because it lines up with being a member of a particular social group and not necessarily a political opinion or a race-based claim or something like that, we've seen a lot of confusion and inconsistency among adjudicators. And the former Attorney General put through an opinion in the middle of last year, which made it incredibly difficult for victims of gang violence or domestic violence to qualify for the refugee definition. And that's something that we're seeing pushback from the federal appeals courts in this country, but it is nonetheless an indication of one of the weaknesses of the law, where we wrote a set of laws for what persecution looked like at the end of World War II, and persecution just looks different now. The numbers of non-state actors, not just in terms of gangs like we see in Central America, but also in terms of non-state actors in other parts of the world, drive a broader definition, perhaps, than what some more conservative politicians would have in mind. So I'll take 30 seconds to say that UNHCR has been working hard to build a regional response to the northern displacement in the Northern Triangle, in particular working to increase the capacity of the Mexican asylum system and to increase local integration in Mexico. But as ever, the capacity there is vastly below what you would see in the United States. So we are not in a situation where, for Central America, it is impossible to say that the countries directly proximate to those countries should be the ones who take care of this situation. And I think that's also true of so many other parts of the world we look at. When we look at Syrians fleeing through Turkey and coming to the European Union, we look at Rohingya moving on from Bangladesh, if that's something. And so that's where I'll end, but to say that we're seeing a lot of pressure on the refugee system from how the Central American situation is playing out in the United States. And it's something that has ripples across the world and something to watch closely. I'll turn over to Kristen, who will speak more about that, I think.
Hi, thank you. I'm going to kind of pick up where Alice left off. I'm going to talk about the family separation crisis, but before I talk about that, I'm going to talk about everything that happened before they started separating families. And that really is about family detention, the detention of families, and particularly the detention of children. And our government has had a policy of detaining children who are fleeing and who are refugees and seeking asylum for quite a long time. The family detention concept was new. That actually came about in the in the mid-2000s. There was a detention center in Texas called Hutto, and they were actually sued by the ACLU and the University of Texas for violating what's called the Flores Settlement Agreement. There has been a settlement in place for many years concerning the conditions of the custody of minors in immigration custody. Under the settlement, there's a preference for the least restrictive alternative for children, and there's a preference for release to a parent or a close relative, unless the child is a danger or presents an extreme flight risk. The settlement says the detention is supposed to be in licensed, non-secure facilities. The conditions are supposed to be humane. Essentially, none of that was happening in the Huddle litigation. They were being held in secure facilities. The conditions were inhumane, and this had been going on for many years. Hutto was shut down shortly after President Obama was elected. The government closed it, but the displacement of refugees from the Northern Triangle that happened in 2014 that Alice referenced led to the creation of new family detention centers. So the family detention centers, there's always been one that was kind of in the background lurking. It's in Berks County, Pennsylvania. It's a small family detention center. It holds less than 100 people. It opened in 2001 and it's never closed. I went there with some of my students in 2011 to look at it. We were doing some work for the ABA to see if they were complying with the conditions of detention and their own rules for the treatment of children, what needs to be happening. It's never good to see children in a locked facility that is, very much like a correctional facility. But Berks, I think about Berks quite a bit because once Obama created the new detention centers, the first one popped up in Artesia, New Mexico in 2014. It's opened in August. I never made it there. I was on my way to go with my students, and then they shut it down abruptly in December 2014. And from what I was told by other people who did make it down there to provide free legal services and advice to help the refugees who were seeking asylum, who were almost exclusively women and children together. And as Alice was talking about, they were fleeing the gang violence, the gender-based violence, trying to help them craft their stories in a way that would allow them to pass their credible fear interviews or their reasonable fear interviews. It was rapidly shut down because, from what I heard, it was completely in violation of everything in the Flores Agreement and also just human rights standards in general. So once Artesia closed, and also it was 6 hours by car from El Paso and 6 hours by car from Albuquerque. So it was in the middle of the desert in the Southwest with no cell phone reception and nowhere to stay. So it was impossible to get counsel, and that's another big issue with all these detention facilities being out in the middle of nowhere and access to counsel. So the two that were opened by under the Obama administration are in Karnes City, Texas, and Dilley, Texas. They're both very close to the Mexican border. Dilley is very large. I think it holds 2,400 people, individuals. I've been there. I've been to Dilley once and to Karnes twice. Karnes was very small. The first time I went, it was less than 500 individuals, but I understand now it's more like 1,500. And every time I went, it was just women and kids. But my students, again, I had another group of students who went back to Berks last year and to Karnes with and to other professors, and it was men and children. And actually, the first time I went to Berks, it was men and children as well. But there was a big gender divide at first with the family detention as well, in terms of who was being held, detained to evaluate their asylum claim and the legitimacy of their fear versus who was immediately turned around and deported, or who was the men were put in separate facilities, and families were strategically separated. If a family unit came together, mother, father, children, the male children and the male relatives were put in detention centers far away, say for Louisiana. The women and kids were held in Arizona. And then that just continued with the family detention. So there's been lots and lots of litigation challenging the family detention scheme for years. In 2015, it really amped up because everybody was challenging the detention centers in Texas under the Flores Settlement. And currently, the Flores Settlement is being monitored by Judge Dolly G. out in the Central District of California in Los Angeles. And she's made some really important rulings about the Flores Settlement applying to accompanied minors. And that's important because the interpretation before had been that the Flores Settlement only applied to unaccompanied minors. So the government had been arguing that we don't have to hold accompanied kids in non-secure facilities because they're accompanied, they're with a parent. Judge G said no, the Flores Settlement applies to all minors. That was affirmed by the Ninth Circuit in July 2016. And there's been several motions to enforce. A special monitor has been appointed to oversee compliance with the settlement terms. But the government keeps appealing and appealing and appealing, even when it gets remanded and they get ordered to do it again. So Flores still has been going on. In 2017, again, at that time it was Flores versus Sessions, because Attorney General Sessions was in charge at the time. That also affirms that all minors in immigration custody have a right to a bond hearing, which the government had been fighting quite hard. The most egregious examples of children being subjected to prolonged detention in immigration custody, which, as you know, is civil custody. So there's no all the attendant rights to speedy trial and all those things that happen when you're in a criminal setting don't apply. A 4-year-old had been detained at Berks with his mother for 655 days, which was something like 2/3 of his life. So this family detention thing had been going on forever, and lots of us in the academic community who run immigration clinics were, like I said, going down to the border and taking our students there and trying to assist with getting the families out, and that was pretty successful. We were able to help people get their credible fear reviews passed, represent people who got negative reviews before immigration judges and get those overturned. But then, as you guys all know, last summer, in April of 2018, the Trump administration announced the zero tolerance policy, and that's when family separation started. It actually started a little bit before then. It was just not, it was not a blanket, well-known policy. What that did was it required universal prosecutions for both illegal entry and illegal re-entry under the federal statutes, 8 U.S.C. Section 1325 and 1326. One's a misdemeanor, the other one's a felony. For the adults, the parents. So if a family was entering together, the policy was that the adults would be criminally prosecuted for those federal crimes, and their children would be taken away from them and taken out of their custody, because children cannot be in the federal criminal custody. So the children were taken away, put in the custody usually of the Health and Human Services Department, which is the Office of Refugee Resettlement is under HHS. And the children were they then became unaccompanied minors, but they were not actually unaccompanied. They were with their parents or a relative. So they got separated, and their parents got criminally prosecuted for the crime of illegal entry or illegal re-entry. And the policy had been to never prosecute people for illegal entry because it's a federal misdemeanor, but the illegal re-entry had been prosecuted. There's been, again, lots of litigation challenging the family separation. There's one in San Diego called Miss L versus Sessions, another one with Hogan Lavelles in San Diego called MMM versus Sessions, and then there's Dora versus Sessions, which is actually out of the Legal Aid Justice Center here in Virginia. Shortly thereafter, there was an executive order issued by the president in June of 2018 called Affording Congress an Opportunity to Address Family Separation. It did not end the zero tolerance policy. It was really just, there was no plan of how to mitigate the disaster, the horrible, the crimes, in my opinion, that had happened where families had been separated. There were some preliminary settlements that came out of litigation, and the settlement classes concerned parents and kids who had been separated from one another on or after June 26th of 2018. But as I said, there's no real plan to reunite these families, and I think the government has even admitted that they have no tracking system for who was separated and who went where. The purpose of the settlement was to also allow the separated families to remain in the U.S. and apply for asylum. And the settlement also emphasizes that families should be reunited so they can pursue their relief together. But the other thing, like I said, when the separation happened, the children got recategorized as unaccompanied minors, and that causes all kinds of procedural protections that are different. The procedure for seeking asylum is different if you're an unaccompanied minor versus an unaccompanied minor. It's usually you go to the asylum office rather than immigration court for a non-adversarial proceeding. I have several clients that are in this situation. It's become very, very hard to kind of get them back together and get them all in the venue. And I have lots of clients whose cases have just been lost in the system. So I'm just going to go ahead and stop. I think the upshot I wanted to kind of get to the audience is that all of the family detention centers are still open. People are still detained there. The families are back to kind of what we did before, where they're held for 20 days, more or less, which is what the Judge G said was kind of the upper limit of detention before release. But the system is overloaded, and it's just a total humanity human rights crisis, in my opinion. Thank you.
Thank you to all of our panelists for raising provocative questions and for sharing their deep expertise on these topics. So first of all, I'd like to invite those who came in later, again, to move up to the front. We are trying to have an interactive discussion here, and that will be much easier if everyone is closer. So I have two questions for the panelists to kick things off. And my first is mostly directed to the question of repatriation, which Itamar, Dan, and Alice touched on in their presentations. So Itamar mentioned that repatriation, and particularly forced repatriation, population exchange, as we used to call it, has always been, at least since 1923, before that even, a concept in international law and has fallen out of favor in more recent years after World War II with the rise of the international human rights regime and the primacy of individual rights, but now maybe coming back now that we have more discussion of moving, you use the word compulsory, I'll say compulsorily or by choice, groups of people, whether because of climate change or because situations of mass displacement have gotten so large that states are interested in solving them quickly and all at once. Obviously, simplifying matters, but I'm an academic, so I have to. So my question is, we have a tension here because we have this idea that keeps resurging that many states find appealing of moving large groups of people at once. And in the international community, some organizations find it appealing to create a repatriation or movement system for large groups of people. And at the same time, they go nowhere. Many of them go nowhere. So Alice, actually Dan referred to the Rohingya, are we calling it a repatriation initiative? Yeah. Repatriation initiative that has gone, UNHCR has negotiated and has actually gone nowhere. And so I'm wondering, first of all, why that is, that these ideas are going nowhere. And secondly, if they should be going somewhere, given that we hopefully as an international community are still very much concerned with the primacy of the individual and individual human rights.
You want to go first?
Yeah, I can start off with the in relation to the example of the Rohingya, and say, you know, there's history of sort of forced returns with the Rohingya in the 70s and then in the early 90s, or at least very questionable kind of how large numbers of Rohingya, not to the scale of today, but large numbers did end up going back. So I think that's one thing to say is, and I think the reason it's not, well, let's say on one side there are things that are happening where maybe on paper, right, where you have the government of Myanmar has agreed with the government of Bangladesh to take Rohingya back. But it's not happening because, as I mentioned earlier, that really behind that there's no real will for the government of Myanmar to take the Rohingya back. And then on the other side, the Rohingya themselves do not feel safe to go back. And then you have from the international side where UNHCR has tried to find ways to be involved. And so instead of there being an agreement between the government of Myanmar, the government of Bangladesh, and UNHCR, it's developed where first there was a bilateral agreement on repatriation between the government of Myanmar and the government of Bangladesh. Then the UNHCR could not, or Myanmar would not allow just a UNHCR Myanmar agreement. So UNDP, the development program, was brought in, but they were able to get that. Then UNHCR was able to negotiate with the government of Bangladesh to get another repatriation agreement. So having to work kind of creatively to make sure that UNHCR or some kind of external third party is there to make sure that this goes along the ways that it should go if the repatriation was to go forward. And there was a push, a bilateral push in November of last year to repatriate Rohingya. And the government of Bangladesh even sent buses and was all set and ready to bring people back. Surprise, surprise, no Rohingya showed up to volunteer. I mean, as I said, people still continue to come across, and they're in communication with their friends and relatives who are still in Rakhine State, and they know it's still not safe. So, so yeah, it's just that those are the challenges to talking about repatriation. Is you can try ways to push it through on the how it's supposed to happen and come up with these agreements, but then when you try to make it actually happen, you run into, particularly in the case of the Rohingya, but I think this is true of other cases where you have to find ways to address the root causes. And when you're dealing with a government like Myanmar that has no real will to address them, that makes this a very difficult situation.
Just a couple of more notes on the aspects of what you said that were kind of regarded or directed towards my comments. I heard the note of question or maybe even a certain kind of critique when you kind of corrected this idea of an emerging discourse or thought about moving large populations compulsorily. So you said, I would prefer to say by choice. And I think that's correct.
Well, I think it's both.
Yes,
I mean,
yes. But I think that part of, at least from the perspective that I'm trying to advance here, when we're talking about the movement by choice of populations that have been or that are displaced due to climate change, and that's and the arrangements that or initiatives that I started to refer to in the last part of my comments, really it does not force people to move. They do not force people to move. They are supposed to allow them or save them. I'm thinking about the Nansen Initiative on Disaster-Induced Cross-Border Displacement from 2012, and a number of other disaster displacement platforms. So I think it's at least worthwhile to think of that kind of movement also as compulsory in a way. I mean, because I don't think these people are choosing to move in a completely free way. And so that's one point. I mean, we may not be in any disagreement. Or another point is when you say that initiatives are going nowhere. I think Daniel Sullivan explained in a very illuminating way one aspect. I think there's also and when you were saying this, I was thinking, people are precisely going nowhere. That's where they're going under these arrangements. So you referred to the island made of silt, which is really a remarkable idea against the backdrop of this kind of history of island detention in the context of migration, going through Guantanamo, Manus and Nauru, the Greek islands under the Greek-Turkish joint statement, and now this island being discussed in the Indian Ocean, I believe. So these are a kind of constructed nowhere that we end up finding these people again and again, precisely going to such weird locations.
Thank you. So my second question for the panel, is Dan gave me a very nice segue into it, is about the question of political will. And it's primarily for Alice and Christina, but anyone can feel free to chime in. So we see in many places in the world that initiatives involving refugees and migrants end up resting on a question of political will, regardless of what the law actually says. Law, of course, plays a role, but politics, as the title of our panel suggests, very much plays into how refugees and migrants are treated. And in my own work on the Global Compact on Migration, that was something that came up over and over again in the intergovernmental debates, that what we really have here is a non-binding agreement and its success or failure is going to rest on political will in all of the countries that sign on to it. For one thing, it's non-binding, so states aren't compelled to follow it. Enforcement is really going to depend very much on what individual populations have to say. And so I'm wondering, based on your extensive work in this area, both as litigators and as working for NGOs and on academic research in this area, how do we generate political will in situations, and I'll add not just in this country, but when people in charge don't necessarily want to change the status quo? How can we generate that among for those of us who want to generate that, how do we generate that in the population overall? And as lawyers in particular, how can we help generate that political will? Easy answer, right?
Yeah, easy. Oh, I do think that the Global Compact is non-binding, but the Refugee Convention is binding. And in states with strong court systems, we've had repeated success bringing some issues of refugee law forward in the courts and having the courts be the entity that, the domestic courts being the entity that can secure some sort of teeth to the binding nature of the convention. That happened recently this happened in the U.S. in many cases in the last 3 or 4 decades, but most recently in a case called East Bay Sanctuary Covenant, which challenged the president's asylum proclamation. The asylum proclamation, in combination with the regulations, said that anyone crossing the southern border irregularly was ineligible for asylum. And the courts pushed back and said, no, like, the U.S. is party to the 67 Protocol and therefore bound to the 51 Convention, and Article 31 of that says you can't do that. And then they went through some of the domestic law arguments too, so it's not an exclusively international law argument. But I do think that we've seen in the US, in Canada, in the European Court of Human Rights, in Australia, in Kenya, in a number of other, Lithuania has had some great success around detention of children. Like, there are ways that domestic courts enforce the Refugee Convention. And I think that is a positive thing. It's by no means enough, and it doesn't, I mean, it may in fact help create backlash against the kind of political will that we want to put forward. So I took the easy part, and I'm going to turn over to Christina.
I think none of this is easy. You know, I think something you said when you were speaking about our current administration and our current law enforcement in the federal government challenging or trying to redefine what it means to be a refugee, and challenging the idea that people who are being persecuted by non-state actors just can't be refugees, and how the problem that creates in our courts and our system now. But I find myself telling lots of people way too many times a week that when people apply for asylum, they're actually following the law, both domestic and international law, that you have a right to apply for asylum. And you don't have to present yourself at the border. You can do that, but you can do it anywhere. But that is the legal mechanism of doing it. And there's this rhetoric and this perception that that here, at least in the United States, there's this rhetoric of law breaking, that somehow applying for asylum is breaking the law, when nothing could be further from the truth. And so I don't know if you can create political will in our populace by trying to emphasize that people who are applying for asylum are actually following the law, and that they have, again, both a domestic and an international right to do so. And our government is a voluntary signatory to the treaties that obligate us to provide them protection. And I think going back and providing the history, I mean, because we don't know our history, we're doomed to repeat it, of why we are a signatory to these treaties. But again, I think there needs to be a lot of discussion too about who is a refugee. I think there is this long, broad, deep belief that people from places like the Northern Triangle of Central America are economic refugees. And that goes back to, probably, longer than the 80s, but that's the part that I remember. And just emphasizing that, that they are refugees, and like you said, there's a gap in the law, particular social group. What does that mean? I'm a nerd too, because I think that's a really fascinating area of law, and that's what we litigate. So I think that you could try to change the political will that way, but I think it's a long, hard slog.
And I'll just add, as as an NGO advocacy group with Refugees International, it's a question we focus on every single day. And I think there's one way that the sort of the political and the legal kind of efforts come together is in examples with Rohingya. Is I talked about the State Department doing this investigation and collecting evidence, and that was there was a big push, and when people were being exposed to these stories, that helped to push that through. It unfortunately fell short of making a legal determination of whether this was crimes against humanity, genocide, and some of the pushback that we've gotten from the State Department is saying, well, we did say it was ethnic cleansing, but trying to explain to them that that's not a legal, there's no legal definition for ethnic cleansing. So if you do come out with those, it's important to come out with those kinds of designations, because then it raises the sense of urgency amongst the general public, and it has some real legal implications. And ways to push the government to do things like that is we do that through working with members of Congress towards legislation, and then all the various accountability efforts that I mentioned earlier. But one of the other ways that I think is really, really important to highlight is getting the voice of the people who are affected onto the global stage. And there's been some important work on that. The State Department just recognized a couple of women from Myanmar as part of their Women of Courage Award, and they came to the U.S. and have spoken to different people. And other people have worked to bring Rohingya refugees from Bangladesh to Geneva for the first time to address the Human Rights Council. So those are some important ways to help to raise the profile and create some political will.
Thank you. And I know that PILPG report is accompanied by a publicity initiative that's going on now as well. So that is, I think, one important way to get the message out there. So at this time, I'd like to open it to the floor, and panelists, if you have questions for each other, feel free to pipe in as well. We'll follow the usual format of going up to the microphone, and if we have a lot of questions, we will save a number for the end, but right now we can get started individually. Please introduce yourself.
Thank you very much. I'm Jim Nafziger, Secretary of ACIL, and I'm on the law faculty at Willamette University. There was brief mention of the Global Compact, or we might say global compacts, because there are two. And I just wondered if anyone would care to expand a bit more, perhaps along the lines of whether it's going to be an example of going nowhere or an example of going someplace. To what extent, falling, of course, well short of anything legally binding at this point, those compacts really are of significance. Thank you.
Jill.
Okay, so I'm not a panelist, but I have been working on the Global Compact as representative of the Academic Council on the UN system for the past 2.5 years. So I guess I'll steal the floor for a second. So I think the answer, and again, this is in my personal capacity and certainly not in really anyone's capacity, but my own. I think the answer is the lawyer's answer of it depends. And it depends what happens from here. So for those of you who don't know what the Global Compact on Migration is, it is a non-binding agreement that has been negotiated by states. It was originally 172 of 173 states that negotiated it, informally affirmed it in July, and then about 150 some affirmed it formally at a conference in Marrakesh at the beginning of December, and 141 voted for a UN General Assembly initiative, which passed, which endorsed the Global Compact. And so it's what a Global Compact is in international law is not clear. But an interesting thing about the Global Compact for migration is that first it was negotiated by states almost as if it were a treaty. And secondly, that states at the conference in Morocco were almost making reservations and declarations of what exactly they thought that it meant. And that a number of states, including the one you're sitting in, felt compelled to withdraw from it at various points in the process, because they were worried, even though it was a non-binding agreement, that it was going to affect their sovereignty in some way. And so that's very strange if states are worried about a non-binding agreement affecting their sovereignty, or at least seems very strange on first blush. But what that says to me is that states are treating this as a norm-producing document, and a document that may have legal implications at some point later down the road. I think, again, and something that came up in discussions, is that a lot of the success or failure of the Global Compact is going to rest on political will, and that we don't know what that is yet. What we do know is that the UN is working very hard right now on coming up with a follow-up mechanism for the Global Compact on migration, at least. Global Compact on refugees has a little bit of a different process, but in order to involve civil society in the efforts and work with states at the state level and at the regional level in order to implement some of the provisions of the compact itself. Whether this generates change, whether this generates uniform change throughout the world, certainly remains to be seen. I am hopeful that it will generate some change, at least at the local levels and at the national levels in some states. I don't think it will become law anytime soon for those of us who were looking for that.
Can I have a follow-up on that?
Yes.
Can it be just the case that states, including perhaps this one, are taking the opportunity to kind of hit on the compact, even if it doesn't have any binding or other legal force, because they're just performing something towards a political, democratic political constituency that wants to hear, bashing of the compact, and so that's the only function of this, and it doesn't reflect any intention to follow the compact later on whatsoever.
So yes, but the way that states are doing this is interesting to me, because the discussion wasn't at the conference in Morocco, where the Global Compact was formally affirmed and state representatives stood up and talked about it, was not the general dialogue we usually hear in the General Assembly, where a state just makes a statement of, oh, we support this, and says something rather benign. States got up there and said, we understand this to mean X, Y, and Z. We want to affirm that. Some states got up there and said, we want to affirm that this is not binding, that this does not have impact on our sovereignty, but this has this meaning to us. And other states got up there and said, we hope this Global Compact becomes law someday. And that's very different than what I at least have seen at other UN meetings. And that suggests to me that this is something more than just your average non-binding agreement.
Yeah, and if I could drill in perhaps on a specific example that might make it feel a little more tangible. One of the things that came out of the Global Compact on Refugees is the idea of what are called CRRFs, which is comprehensive refugee response frameworks. And they've been piloted in at least 3 areas. One of them is Uganda, another is Northern Central America, and there in Northern Central America, instead of being called CRRF, it gets translated into Spanish and then gets referred to as the MERPs, which is terrible. But setting aside the acronym, these are sort of an idea that from the Global Compact, we're hoping to drive some sort of deeper policy response to the idea there is no long-term solution to most refugee migration issues right now, right? That like the traditional durable solutions we've worked with for decades are really not working. We discussed repatriation and return. Resettlement is all but dead given where this country has gone on it. And so local integration is kind of the only option at the moment. And that's really where these comprehensive refugee response frameworks are pushing forward, is really to say, if we're going to have local integration, we need a more comprehensive response to that. And I think one of the interesting things that's going on is that they've brought in development actors much more clearly than before. There's now a much broader role that the World Bank is playing in these sorts of efforts. And it's with an eye towards trying to pull up local communities as well as the refugee communities. So with an idea that serious local integration means investing in everybody who's there. And so very concretely, we are running a program in central Mexico in the industrial corridor there in cities like Saltillo. The economy is thriving and there are more jobs than can be matched by local residents. And Mexico has agreed to take some of the asylum seekers who are typically staying in southern Mexico and bring them to this area. The numbers are tiny right now, but where this program is, it's working. Like 86% of people are staying in the program and not migrating onto the United States. So is the Global Compact going to have massive binding legal impact? I don't know, but it is forcing open a policy conversation that I think is perhaps useful.
Great. Yes, I would say that's true for both global compacts. Yes.
I'm curious.
Can you introduce yourself?
Sorry?
Introduce yourself, please.
Yes. My name is Shalaka. I'm from UCLA School of Law. And I'm curious what members of the panel think about responsibility for countries of origin of these refugees. There was a proposal put forward by Blocker and Gulati of instituting financial repercussions, payments by countries of origin, especially when they have a direct hand in persecution and it's not a conflict. And there was a response from UCLA's Tendai Achume, who's also the special rapporteur, where she talked about one of the problems with that idea being this political issue of xenophobia. And it wouldn't actually work and it wouldn't have the impact on refugee and migration movement that we think it would. So I'd be really curious to hear your thoughts on that. Thanks.
I can briefly say something to that. Thank you for the question. So I think that the conversation about repercussions for countries of origin is a very old, I mean, it goes decades back. It's not really a new thing. And I think it's has often also been cast in terms of military intervention, not only financial repercussions, but also military intervention earlier on. And I think that it's really really risking generating a dynamic of increased conflict and increased cracking down on asylum particular groups that then become refugees as a pawn in a kind of conflict. So I don't know exactly what I mean. I can imagine what Tendai Achume has said regarding xenophobia. I think that the aspect that I would be worried about is that the results towards groups that are vulnerable could be very, very bad, and they can be. It can encourage and incentivize a dynamic that occurs anyways, by which these countries sometimes make use of migration flows for political interests and to generate pressure towards other governments if they're inflicting various forms of sanction.
Okay. We have about 10 minutes left, so I'm going to ask anyone else who has a question to join the queue, and then the panelists will take all the questions at once.
My name is Brendan Neff. I'm from the Library of Parliament in Canada, and I have a follow-up question, not a follow-up question, but a question that plays off of political will a bit, namely rhetoric. I find in my role as an analyst, in the stuff that I write, but as well in what I read, people quite often open their pieces, especially civil society groups will open their pieces by talking about kind of a dire situation and a crisis. Sometimes the word crisis isn't always used. And what I've found is I've had to tone back my own writing and stop referring to things as crisis, because I found that it's used in rhetoric. It's basically adopted. And I guess my question is how to point out something that needs reform, the importance of migration flows, but without scaring populations that are very vulnerable to populist arguments. My example of this, I guess, is walking the streets in Ottawa. I ran across some people wearing yellow vests, and I said, "What are you protesting?" And they said, "The Global Compact." And when we talked about it, they really had no idea at all what the Global Compact was. And if they're going to protest something that's not even a treaty, I think that's an indicator of, how sometimes dangerous it is for us to label things as crisis when our current institutions can probably deal with it with reforms.
Thank you.
Hi, I'm Daniel Costa with the Economic Policy Institute. Sorry to take it back to the Global Compact, but I just have one question about that. So the Global Compact is definitely not law, but it's also not nothing.
Refugees, migration.
Migration, sorry.
Okay.
Sorry, migration, specifically on
Both, but both are not law.
Specifically on migration. So whatever that not nothing is now going to be quote unquote serviced by the IOM. It's going to be the lead agency on the Global Compact for Migration. And I think there's the IOM is now also affiliated with the UN. Whatever that means is not totally clear yet. It's a part of the UN, but it's also, and I'd like the thoughts of the panel on this. It does not have a human rights mandate, and it's going to be servicing this Global Compact, whatever it is, without that human rights mandate. And I find that very problematic. And in some ways, you might have the IOM managing labor migration without having the ILO, playing what should be a primary role because it has a human rights mandate and it's got a tripartite structure. So do any of you see any problems with that? What do you think about that? The Secretary General of the IOM was here in DC just a couple of weeks ago. He was asked about this directly. He did not give a very satisfying answer. So I would love to hear the panelists' thoughts. Thank you.
Hi, my name is Christina Cerna. I'm an adjunct at Georgetown. I have two little questions. One is on the Rohingya. If Daniel could maybe explain a little more what their status is in Bangladesh. Are these people like the Mosquito Indians who lived in Nicaragua and Honduras on both sides of a border? Are there Rohingya in Bangladesh? Not those that came from Myanmar, but does this community exist in Bangladesh? And why do the people in Myanmar call them Bengalis? And the second question is, it's a bit perverse. It's thinking about the question of what kind of sanctions could be put on countries of origin that produce vast amounts of migrants. Looking at the example of Venezuela right now of creating this parallel government, delegitimizing the government of Maduro. In Honduras, for example, the last elections held in Honduras, the incumbent president who was prohibited from running for re-election ran for re-election. The election observers found many irregularities in the election, basically calling on the election to be held again. Nothing was done, but could one, using the model of Venezuela, contrive, because of the vast amount of migrants coming out of Honduras, a delegitimization of the government of Honduras and look for some kind of parallel government to support.
Okay. Okay, we have about 4 minutes and 30 seconds left to cover all of that. So I will turn it over to the panel to address the question of groups, first of all, groups calling refugee and migration crises a crisis, and whether they are in fact crises or not, and whether existing institutions can make reforms in order to deal with what we call crises sometimes. The question of whether, if there's a tension between the fact that IOM, which just joined the UN in 2016, does not have a human rights mandate, but is primarily the primary agency in charge of implementing the Global Compact on Migration. And then 2 questions on the status of the Rohingya and on sanctions, on the question of sanctions on countries of origin.
I'd like to say something about the crisis question. I think you're absolutely right that there's a lot of rhetoric about things being crises. And when you were talking, I was thinking about when all the family detention centers were being opened in 2014, the rhetoric here in the US was that we had a surge. That was the word they kept using. It was a surge of unaccompanied alien kids and a surge of these, people coming from Central America. And that gave rise to, I actually wrote a law review article about this a few years ago when this was happening, because it really gave rise to all kinds of other rhetorical devices that inflamed people that were paranoid and xenophobic, and all the horrors and the parade of terribles that were going to happen if there was this surge of unaccompanied alien kids. And there were even people that, it's ridiculous. There was a group of people that said the children were like human shields that were being sent into the U.S. to kind of protect like terrorists that were coming. But I think you're right that this whole idea of crisis is overblown, and I think a lot of times it's used to garner that kind of populist fear, but also I think sometimes it's to shield an actual crisis. Like I think what's happening in our border right now, on the southern border, there is a humanitarian crisis, but the rhetoric around it is that we had the caravan, right? We had this caravan of people coming, and so they said that was a crisis. And so now there is a crisis, but it's because everybody said there was a crisis. Do you understand what I'm saying? So I don't know how to change that, but I think you're right. We need to be careful about what we do call a crisis, because then I think it inflames passions that are already there, and I think it makes people who are susceptible to that kind of inflammatory rhetoric really energized in a negative way.
I just got the 2-minute signal from ASIL, so.
Sorry. I'm done. Yeah, I'm done.
I can go quickly on the Rohingya question. There's a really long answer and there's a short answer. It's all tied up in the whole history of colonialism and all kinds of things that, in changing borders and kingdoms along where Bangladesh and Myanmar are. But the fact is that the Rohingya have been there at least since Myanmar got its independence. There is some affinity with Bangladeshis, but they do have their own distinct language. It's similar to some of the dialects in Bangladesh, but there's a history of the Rohingya. I've met those who served in parliament in Myanmar, and they've been able to vote in the past. But the stance of the government of Myanmar right now is that they just want to refer to them as Bengalis. There's a religious element here. The Rohingya are Muslim. The majority of those in Myanmar are Buddhist, and there's some dangerous rhetoric there. But I think the fact is that the Rohingya have a right to self-identify. They identify themselves as Rohingya, and the government of Myanmar refuses to accept that there even is any group of people called Rohingya, and for any kind of chance at citizenship, they would require the Rohingya to give up their own ethnic identity. So that's a short answer to a much deeper problem that will require more discussion. So.
Perfect timing. So I will close with a few quick thoughts summing up the discussion that we've had here. I think we've talked about the importance of how words really matter and how we describe displacement crises, refugee crises, migration crises, and even those very words, refugees, migration, matter very much for how displaced people are actually treated, and also for the generation of political will to help them. And I'd also like to say that happily, I hope, that law matters very much, and law still matters. The legal frameworks that we have still matter, and probably have helped more people than sometimes we give them credit for. But there's a lot of work still to be done as lawyers, as academics, as researchers, as advocates, as NGOs, in order to ensure that these existing legal frameworks are able to help as many people as possible. Thank you.